Dear viewers, today I want to deal with one important aspects of India's democracy. In fact, one of the most important institutions of India's democracy, that is the Indian judiciary. My discussion is divided into two parts. In section 1, I shall try to give an outline of the structure and organization of the Indian judiciary in general. Section 2 of my lecture is confined to a discussion on the high courts in different states. Let me begin with the first section, that is the structure and organization of Indian judiciary. India, as we all know, is a federal state, and in all federal states there are two types of government, central government and state governments. Naturally, there are dual executive, dual legislature, dual judiciary. We have in India dual executive, dual legislature, but no dual judiciary. In fact, we have consciously adopted, the framers of our constitution consciously adopted a single integrated judicial system for the entire country. And in this respect, we have followed the pattern in the Government of India Act 1935. And this integrated judicial system, according to B.R. Ambedkar, the chairman of the drafting committee of the Constituent Assembly, was essential for maintaining the unity of the country. Now, at the lowest level of the judicial ladder are the subordinate courts. There lies the subordinate courts. Any court other than the Supreme Court and High Courts are called subordinate courts. These subordinate courts are subordinate to and under the control of the High Courts. Part 6, Chapter 6 from Article 233 to 237 deal with these subordinate courts. The powers and functions of these subordinate courts are contained in the Code of Civil Procedure and the Code of Criminal Procedure. In addition to these, various acts passed by our Parliament confer jurisdiction on these subordinate courts. Above the subordinate courts, there is a High Court for every state in India. The High Court stands at the head of the judiciary in the state. The High Court is an old institution. The High Court dates back to 1862, when under the Indian High Courts Act 1861, 3 High Courts were established in 3 presidency towns, that is Calcutta under the Bengal Presidency, Bombay under the Bombay Presidency, and Madras under the Madras Presidency. Subsequently, other high courts were established in different provinces. On these pre-existing foundations, our constitution builds the structure of the high courts in India, in independent India. Chapter 5 of Part 6, from Article 214 to 231 of the Indian Constitution, deal with these high courts. As already stated, there shall be a high court for every state. The Constitution further lays down that there shall be common high courts for 2 or more states. Accordingly, the Guwahati High Court at what is now known as Guwahati in Assam is the common High Court for 7 sister states. So this is laid down clearly in the Constitution that the Parliament has the power to establish common High Court for several states. Delhi is the only union territory which has a High Court of its own. Next, at the apex of the Indian judicial system, above the High Courts, there is the Supreme Court of India. Before India adopted its new constitution in 1950, there was a federal court established under the Government of India Act 1935. So the federal court before the commencement of the constitution was the highest judicial organ in India. It was the apex court, but it was not the highest court of appeal. The highest court of appeal was the Privy Council in London. So appeal could lie from this federal court to the Privy Council in London. This federal court became the Supreme Court of India after the inauguration of the Constitution in 1950. Article 124 to 147 in Chapter 4 of Part 5 deal with the Union Judiciary, that is the Supreme Court of India. The Supreme Court sits in New Delhi. So that is the outline of the structure of the Indian judiciary. Now I proceed to deal with the second section, that is High Courts in different states. As already stated, that the High Court stands midway between the subordinate court and the apex court. Every state has a High Court. And it is further stated that there may be a common High Court for 2 or more states or union territories. Now, the composition, the strength, the appointments of the judges of the High Courts. It is laid down in the Constitution, particularly in Article 216, that every High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary. So the number of other judges will be decided by the President himself. Now, next, the appointments of the High Court judges. How they are appointed, who appoints them. The Constitution lays down in 217 that the President appoints the judges of the High Courts as well as of the Supreme Court. While appointing the judges, he must consult some constitutional functionaries. Constitution says that while appointing High Court judges, the President shall consult the Chief Justice of India, the Chief Justice of the concerned High Court, the Governor of the concerned state. What is not laid down in this article 217, that the President will also consult Union Council of Ministers led by the Prime Minister. Why? Because it is laid down in Article 74, Clause 1, that there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President in the discharge of his functions. So while discharging his functions of appointing a High Court judge, the President will have to consult the Union Council of Ministers in terms of Article 74, Clause 1. So there are different functionaries. Here, the Council of Ministers, Union Council of Ministers, the Chief Justice of the High Courts, Chief Justice of India, etc. So, whose opinion would be given the most importance. Naturally, up to 1990s, the opinion of the Union Council of Ministers were considered most important. Although the Chief Justice was consulted, but his opinion was not given primacy up to 1993. So there has been a change after 1993. So while discussing the appointments of the judges of the High Courts and in fact of the Supreme Court, this is similar to appointments of the Supreme Court, two stages must be taken into account: before 1993, after 1993. So before 1993, the judges of the High Courts were appointed by the President after he consulted with these functionaries already stated. But the opinion of the Chief Justice was not considered the most important. The position changed after 1993. The question may be raised that whether the constitutional provision regarding the appointment of High Court judges, whether these provisions have been amended. The answer is no. Then how is it possible that the procedure for amendment has changed substantially after 1993? Because there has been a judgment of the Supreme Court in a well-known case, SC Advocates on Record versus Union of India 1993, where the Supreme Court gave its opinion that the consultation with the Chief Justice of India is not only obligatory on the part of the President must concur with the views expressed by the Chief Justice of India. Now, it is further stated in the judgment that the opinion of the Chief Justice would be formed only after consultation with two senior-most judges in respect of appointment of the High Court judges and also of the appointment of the Supreme Court judges. Now, there was a third case known as the third judge's case, but it was actually reference. That means the President sought an advisory opinion from the Supreme Court. In 1998, Supreme Court reaffirmed its view, saying that the views of the Chief Justice regarding appointment and as well as a transfer of High Court judges from one state to another, the opinion of the Chief Justice would be given the most importance. So this is how the judges of the High Courts are appointed after 1993. So the Union Council of Ministers virtually has virtually no control regarding the appointment of judges of the High Courts. Now, I discuss briefly some of the essential points like qualification for High Court judges. A person to be appointed as a High Court judge must be a citizen of India, must have held judicial office at least for 10 years, or he must be an advocate of a High Court or two or more High Courts for at least 10 years. His tenure, that means he retires at the age of 62, unlike a Supreme Court judge who retires at 65. He may resign before his retirement. The resignation must be addressed to the President of India. There may be vacancy caused by his transfer from one court to another, from Calcutta High Court to Madras High Court. Or he may be appointed, a High Court judge may be appointed a Supreme Court judge. And finally, the vacancy may be caused by his removal. He may be removed from office before his term ends. Who may remove him? the President may remove him. The grounds already stated in the Constitution, on grounds of proved misbehavior and incapacity. So his behavior and incapacity has to be proved, and there are detailed procedures laid down not only in the provisions but also in the Judges Enquiry Act 1968. A detailed procedure has been laid down. A prolonged process has been laid down for removing a judge from the post of High Court judge. And here the Parliament comes into the picture. Before that, a committee constituted by the Chief Justice of India will give a report to the Parliament. The Parliament will consider this aspect in detail. Then a resolution has to be passed in both houses of Parliament by a special majority. Means by majority of the total membership of each house and by 2/3 of the members present and voting. Only then and then only the President of India will remove a judge of the High Court and in fact also of the Supreme Court. So because the process is similar in respect of both High Court and Supreme Court judges. As in the case of the Supreme Court judges, the Constitution seeks to ensure independence of High Court judges in different ways. It is clear to all of us that the judges must act impartially and independently. That is, they must act independently of executive control. The executive mustn't and cannot interfere into the affairs of the judiciary. And they must act without fear or favor. So there are certain provisions in the Constitution. For instance, the judges cannot be removed simply on the pleasure of the President. The Constitution never says that the judges are to hold office during the pleasure of the President. They don't say that. That means the tenure of the judges of the High Courts as well as of the Supreme Courts are fixed. If the executive wants to remove them, the President wants to remove them, the President can remove the judges of the High Court only on grounds of proved misbehavior and incapacity, as already stated to you. In case of jurisdiction of the Supreme Court, the Constitution clearly lays down the different jurisdictions of the Supreme Court, but no such detailed description about the jurisdiction of the High Courts have been laid down in our Constitution. The Constitution simply says that the jurisdiction of the High Courts and its associated powers are to be the same as were enjoyed by the High Courts before the commencement of the Constitution. So, what were the powers that the High Courts enjoyed before the commencement of the Constitution? For instance, the High Court previously had original civil and criminal jurisdiction before the commencement of the Constitution. Now, under the Criminal Procedure Code 1973, this power of original criminal jurisdiction has been totally taken away from the High Courts. So High Court is no longer has original criminal jurisdiction, has no longer jurisdiction in criminal matters since 1973. But the High Court has limited original civil jurisdiction. Why I say limited? Because in independent India, after the commencement of the Constitution, city civil courts have been established in different cities where these courts rather try civil matters in its original jurisdiction. So civil matters of lower value are taken up by city civil courts. But the High Court still retains right of original jurisdiction in civil matters of higher value. So this is a change that should be taken into account. High Court has appellate jurisdiction in both civil and criminal matters. That is, the case has been taken up by a lower court where the aggrieved party which is not satisfied with the decision of the lower court, subordinate court, may move the High Court on appeal, both in civil cases and in criminal cases. That is another important aspect that need to be taken into account. And the third jurisdiction that is most important is the writ jurisdiction. Writ is a remedy for the enforcement of fundamental rights. The Supreme Court of India has been given this power, this jurisdiction, writ jurisdiction, for the enforcement of fundamental rights. The Supreme Court can issue the writ of habeas corpus, mandamus, etc., for the enforcement of our fundamental rights. And as we all know that we have right to constitutional remedies and important fundamental rights. So we can move the Supreme Court straight away for the redress of our grievances, for the enforcement of our fundamental rights. The High Court similarly, under Article 226, has the power to issue these different writs like habeas corpus, mandamus, like the Supreme Court of India, for the enforcement of fundamental rights as well as of other constitutionally recognized rights. So a question may be raised, what are these constitutionally recognized rights which are not fundamental rights? For instance, right to vote is a constitutionally recognized right. It is not a fundamental right. It is not within the chapter of our fundamental rights, but it is a right contained in Article 324 of our Constitution. So it is a constitutionally mandated, constitutionally recognized right. If this right is taken away, if this right is infringed, we cannot move the Supreme Court, because the Supreme Court is unable to enter into this aspect. The Supreme Court can only take up a case where there is a violation of fundamental rights. But right to vote by every citizen of India is not a fundamental right. So if this right is violated, we must move the High Court and not the Supreme Court, because the High Court has the power only to protect our constitutionally recognized rights as well as our fundamental rights. So the jurisdiction of the High Court in this matter is wider than the Supreme Court. And finally, two other points. Every High Court has a power of superintendence over all courts and tribunals in India below the High Court. Tribunals means quasi-judicial bodies. So the High Courts have power of superintendence over all these lower courts, over all these subordinate courts. And this power of superintendence is very broad. It extends to administrative as well as judicial superintendence. And lastly, control of the High Court over other subordinate courts. That means the High Court is the head of the state judiciary. Hence, it can exercise administrative control over all other subordinate courts in India. Some statutory and constitutional changes have taken place recently regarding the appointment and transfer of judges of the higher judiciary. These changes have to be taken into consideration while examining the procedure for appointment of the judges of the higher judiciary. The significant changes that have taken place recently are: one, there has been a statutory change in the sense that the National Judicial Appointment Commission Bill has been passed by Parliament in 2014, and the President gave his assent to this bill. So this is now an act, that is the National Judicial Appointments Commission Act. To make this body constitutionally secure, the relevant provisions of the Constitution have also been amended by the Constitution 99th Amendment Act 2014. As a result of these changes in the relevant provisions, particularly in Article 124 regarding the appointment of Supreme Court judges, Article 217, which is concerned with the appointment of the High Court judges, Article 222, which deals with the transfer of High Court judges from one state to another, have already been amended by the Parliament recently. Now, this proposed National Judicial Appointments Commission consists of 6 members. These 6 members are: 1, the Chief Justice of India, who is the chairperson of this commission; 2 senior judges of the Supreme Court; 3, the Minister in charge of law and justice in the central government; finally, 2 eminent persons to be appointed by a committee consisting of the Prime Minister of India, the leader of the opposition in the Lok Sabha, and if there is no such leader of the opposition, then the leader of the largest single opposition party in the Lok Sabha, and the Chief Justice of India will nominate these 2 eminent persons. It is further laid down that of these 2 eminent persons, one must belong to the SC, scheduled caste, or ST, the scheduled tribes, or OBC, other backward classes, or minorities like the Muslims or Buddhists, etc., or women. Now, this commission has not been formed as yet, because the central government thinks that the matter, the constitutionality of the National Judicial Appointments Commission Act has been questioned in the apex court. Unless and until the matter was disposed of, settled, the central government has decided not to form this committee as yet. So, the existing collegium system, the existing system of appointing the judges by a collegium of 5 Supreme Court judges still continues.